Okay.
Thank you. We're going to get started this evening. I'm Mary Sue Lanigan, and I'm with the Michigan Parkinson Foundation. And I want to thank you all for joining us. Tonight, we are just delighted to be able to have Mike Rutkowski. He is going to talk about the elderly and the law, understanding VA, Veterans Administration benefits, Medicaid, and advanced directives. He is with, of course, the Rutkowski law firm, estate and elder law. And so now I give you Mike, and I think you're all going to find this presentation very interesting. Okay, Mike, and you're going to share your own slides?
Yeah, absolutely. Okay. Yep. So thank you for the introduction. Yeah, like she mentioned, I'm Mike Rutkowski. We're a estate preservation and asset protection firm, and so we're going to talk a lot about what that is tonight. Talk general estate planning, and then also how we plan for long-term care if we haven't done anything for that. So I'm going to start sharing my screen.
I'm going to interrupt you 1 second. Folks, sure. I'm going to mute everybody. And then at the bottom of your screen, you should see an icon that says chat. If you have any questions during the meeting, write the question and I will monitor it. And then we'll ask Mike at the end. And I will unmute you afterwards so that you can ask verbal questions. But right now, I'm going to mute you all, okay?
Okay.
Yeah, like she mentioned,
wait a minute. Mike, I'm having a hard time. I'm trying to get you unmuted. You good?
I think I'm back.
Yeah, you're back. Sorry about that.
Okay, I'm back.
Okay.
All right, perfect. Thanks, Kevin. Yeah, so like she mentioned, put your questions in. We can definitely take as long as you guys need to go over any specific questions you have related to the material or just anything else in general related to estate planning, long-term care planning, asset protection, those kinds of things. Also, a little bit about our firm is, since quarantine happened, we've been doing a lot of virtual planning. So just like you all are on a Zoom call right now, we've been doing all of the planning for all the families that we've been working with through Zoom, and it's been great. So you don't even have to leave your couch. We have the ability to send documents to you, have them signed through Zoom. The feedback on this process has been great. So, if you like how this goes and you're used to doing Zoom now because we're all used to it after being locked in our houses for so long, feel free to take advantage of that process that we've got going on. So I'm going to go ahead and share my screen. If there is a specific question that someone has related to the material, feel free to jump in. I have no problem just using the slides as more of just a guide for the conversation tonight. I just want to make sure that everyone gets their questions answered. We have offices currently. One thing I didn't mention, we have four locations that serve the entire state. So we've got 3 in southeastern Michigan, and then we've got 1 over in Kalamazoo. But like I mentioned with the virtual planning process, we've been serving families up in northern Michigan, Lansing, Traverse City. It's been a unique experience, and we've all really enjoyed it. So let's dive into the material a little bit. Let's first talk about incapacity planning and what that is. How can you plan for it? What happens if you don't plan for it? Let's talk a little bit about that. So first, let's talk about what is incapacity. And in the legal world versus the medical world, there's a clear difference in what it means to have the inability to make your own decisions. And so that's really what we're talking about. But a lot of times, someone might be deemed incapacitated by a physician, unable to make their own medical decisions. But in our world, it's not too late to still sign testamentary documents like wills, powers of attorney, and that can be really important. As long as someone understands essentially these things, what they have, who they want to help them, we can still execute a power of attorney, a will, a trust. So just know that there's definitely a different standard there when it comes to the ability to execute a document versus a physician just saying you can no longer make your own medical decisions anymore. And that really falls on us, on our shoulders as attorneys, to evaluate the situation and the individual as to what their capacity level is. And what I mean by the situation as well is, there's a heightened standard if someone's saying something along the lines of, I want to disinherit all my kids and leave everything to my neighbor. Okay, well, there's going to be, if that ever got in front of a judge, they're definitely going to look at that and they're going to want to know, okay, what was the relationship? Why did the person disinherit their kids? Was there a long-standing bad relationship between the kids, or was this just a something as it relates to dementia or something that maybe the person wasn't clear in their decision making? So that is looked at with a heightened level of scrutiny versus something like, I just want to leave everything to my kids equally, and I appoint them in order to be my trustee and power of attorney from oldest to youngest. I mean, that's a pretty typical situation, and something like that would be looked at a lot less, critically if it ever got in front of a judge because someone was contesting something. So just know, though, that there's a different standard in our world versus the medical world, and sometimes it's not too late, and it's worth getting in touch with an attorney to see if something can still be done if someone might be in that gray area of being able to make their own decisions. So let's next talk about what can you do to plan for incapacity. In our world, there's power of attorney documents. And what power of attorney documents are essentially you're deciding what someone can help you with and who are going to be those people that help you in the event you can't make your own decisions. Now, there's a financial power of attorney and a healthcare power of attorney. And a good comprehensive power of attorney document lays out when can someone help you, like what's the standard in which this document now works. It's called a springing power. Unless it's a spouse that you're delegating that power to, you typically don't want to give away that power until you can no longer make decisions for yourself, right? I mean, why would you want to give your kids the ability to make those decisions for you if you still have all the capacity to make those decisions for yourself? So the first decision to make is, when does this power of attorney actually start working? And then from there, you talk about, what powers am I giving to this person to help me with? In a financial power of attorney, that can cover everything from being able to call Verizon Wireless or AT&T because you need to change your wireless plan, or maybe even cancel your cell phone because you don't need it any longer, to much more important decisions like, when do I sell my home? Okay, like who can sign off on selling my home because I no longer need to live there? So there's a wide range of transactions that a person can handle as your financial power of attorney, and you having the ability to pick what powers you want to delegate to that person is really important. Same thing with the healthcare power of attorney. There's some different pieces to that healthcare power of attorney for a comprehensive one. There's definitely it goes by a lot of names. People have heard it called a healthcare proxy, advanced directive, healthcare power of attorney. Essentially, they're all the same. They're just different names for the same thing. But who's going to be that person in charge of your healthcare decisions if you can't make those decisions for yourself? And this might be a different order. If let's say you got 3 kids. Well, maybe one's better with financial stuff and the other one has a more level head when it comes to making healthcare decisions for you. Or a classic example of, like, you got one kid who's a nurse or a physician, and you got another one who's a CPA or a financial advisor. Well, it would make sense to maybe have each of those people help you in their respective fields. So those are your choices to make. In that healthcare power of attorney is also something called HIPAA waiver. So what this does is that those same people that you appoint to help you with medical decisions, it also gives them the ability to have access to confidential medical records and information. You know, this is important because, you know, let's say, even if we're not talking about incapacity planning, but let's say you're in a car accident on your way up north Michigan or something for 4th of July weekend, and you're rushed to Traverse City's hospital. Well, your kid cannot just call up the hospital and say, hey, what happened to mom or dad, unless they have this HIPAA authorization that allows them to disclose this information. So that's where this can be really important, so that, you know, your kid's not racing up to Traverse City to find out what happened to mom or dad. They're able to find out that stuff over the phone. That's kind of what this can be really important for. And then the last section of a comprehensive healthcare power of attorney is a living will. This is your end of life decisions if ever in a coma or vegetative state. So for lack of a better way to describe it, this is like the pull the plug instructions. You know, do you want artificial life support? How much artificial life support do you want? There's a lot of decisions that go into this, and just making all these decisions in advance really just kind of takes that burden off your kids to like take a guess at what mom or dad might have wanted. So you get to pick it in advance, because if one of your kids maybe has to make this decision for you, it's obviously a very emotional time where they might not be thinking clearly. And if you've laid this all out exactly what you want, it's just their responsibility to just follow through with what you had decided in advance. Some of the misunderstandings or misconceptions about powers of attorney documents is that we see people try to use them all the time after someone has passed away. And power of attorney documents only last until death. Once someone passes away, now those documents no longer work, and now we're on to, you know, who gets your stuff, how does that work, and that's usually all governed through a will or a trust, and we're going to talk about that in a little bit. But in planning for incapacity, powers of attorney are a great start. They can be a very powerful tool, and in our experience as elder law attorneys, we find that the journey typically through incapacity until passing away is so much more complicated than just making sure someone's assets avoid probate and go to the kids how you may want them to go. You know, just dealing with transitioning through all types of levels of care and stages of any type of mental capacity issues can be so much more emotionally draining, as well as complicated in the legal world, than just avoiding probate. So we find that incapacity planning is a very important part of our practice. So let's next talk about, what if someone did not plan? You know, what if there are no powers of attorney in place? What if you have a power of attorney that's, for lack of a better way to describe it, expired because the law has changed and it's no longer accepted? We typically find that institutions, whether it's healthcare institutions or financial institutions, they typically want to see your power of attorney documents 3 to 5 years old. And we find that they have difficulty accepting them after that, which they're not really leaning on any rule that says a power of attorney expires, because it doesn't. But for whatever reason, they feel as an institution that they can decline accepting one once they become like 5 years old, which is the craziest thing. And we're fighting with institutions all the time about that. And, you know, because truly, you never really need to use these documents until you need to, because you don't have the capacity to do something yourself. And now we're in a spot where we can't sign new ones. So it's kind of like a catch-22 on that. So for all the families that we work with, we like to keep them updated, even if it's just throwing a new date and signature on them every about 3 to 5 years, just to make sure that we don't run into those struggles with an institution not accepting a power of attorney. So now let's talk about if you don't have those powers of attorney in place. This is where someone would have to go be appointed as your guardian and or conservator. The difference between the two is that a guardian takes care of your physical well-being and the conservator takes care of the financial side of things. And all this can be avoided with good powers of attorney documents. But now we don't have those in place. So now we have to petition the court. And as we talk tonight, you're gonna realize that a big part of our practice is avoiding court, because court is time consuming and expensive. You know, anytime you have to do anything through the court system, especially right now, we just saw, we were working with a lady last week who we needed to petition the court for guardianship, and they're not scheduling hearings until end of September. So, which means we don't have someone, a point person, to make these decisions for this lady, and I feel terrible about it. And until it rises to the level of becoming an emergency, which an emergency in the court's eyes is someone being financially taken advantage of, whether it's by a kid or by another individual, that's one standard, that it rises to the level of an emergency, so we could do it through Zoom. If that doesn't happen, we're sitting on our hands until end of September before someone can make decisions about, you know, maybe transitioning this person to another facility where they can get better care, or, you know, all kinds of bad things can happen between now and September. So it's really terrible with everything going on and the courts being closed, but which just really emphasizes the need to do planning in advance. But so, you know, so with the guardianship, as you can see in the slide, you know, who is an appropriate guardian for someone? The statute has an order of priority. What that means is that it's not automatic that a spouse would be your power of attorney, or one of your kids would be your power of attorney, or not power of attorney, but guardian. How the priority works is, if you ever put a power of attorney in place during your lifetime, that person will automatically get priority in the list of people, because that's showing the court that at some point in time, you trusted this individual to make those decisions for you. And I can't tell you how often we see outdated power of attorney documents where maybe they had one of their, you know, one kid as their power of attorney, and now they're like, yeah, I don't think that person makes sense anymore. Now it will be this person, my daughter, or whoever. But whoever you appointed at any point in time in a power of attorney document automatically gets priority in the court's eyes. Then from there, it's a pretty typical list of spouse, kids, relatives, that kind of thing. But here's the deal: it's most likely probably not the person that you wanted. You know, you had the ability, while you had the capacity to do so, to pick who these people are, and you can pick an order of people. You can say, you know, my spouse first, if you have one, and if not my spouse, because he's either passed away or can't do it because he's incapacitated, he or she, then I would go to my kids, and my kids in this order. I would go Johnny first, Sally second, Mary third. You get to pick that order, and you know, there's a lot of things that go into who would be appropriate, geographical location, just things that they might be better at, whatever the case may be. But you know your kids, so you can pick the order. And it doesn't have to be your kids either. You know, you can pick whoever you want, anyone else in the world, you can pick. So with that, it's a super easy document to put in place, avoids the whole court system. A guardianship typically runs about anywhere between $2,500 to, let's say, you could go as high as like $15,000 to $20,000 if the kids are going to fight over who's going to do it. And I've seen it happen too. I've seen kids just start going at it. They're all hiring their own attorneys to see who's going to be guardian of mom or dad. And now we're just wasting time, wasting money. The conservator, like I mentioned, is handling the finances for someone. Now, with both the guardian and conservator, there's annual reporting that has to happen to the court. You have to show what was all the money spent on. Every year you have to go into court, which is obviously time and money. None of that has to happen with the power of attorney. There's not that court oversight with the power of attorney like there is with the guardian and conservatorship. So super important documents to put in place to avoid all of that. We can answer questions on that. We'll talk later. Okay, so let's just go into a little bit of estate planning 101, I like to call it. Let's talk about
Before we head into estate planning 101, would you mind turning your microphone on and then off again just to test it, because it's breaking up pretty badly?
Mine? Okay.
Yeah. Thank you.
How are we now? Any better?
Seems to be.
Okay. Yeah, feel free to jump in and let me know if that happens again. I'm on a Wi-Fi hotspot. I'm down in Myrtle Beach. I didn't tell you guys this, but I'm down in Myrtle Beach with my family, so we're making it happen. Just let me know if it cuts out again. So let's talk a little bit about, these are the documents available to you when it comes to estate planning. These are the general documents. We've talked about the financial power of attorney, the healthcare power of attorney. Now let's talk about someone's passed away, and now who gets your stuff? And that's where really a will or trust comes into play. And so we're going to talk about the differences between a will and trust, and then also we'll go into a little bit about funding and how important that is. So let's talk about basic differences between a will and a trust. So a lot of people call our office for a will. And I think the biggest misconception that we get about wills that people don't know is that a will still goes through probate. So what a will really is a will is just a suggestion for a judge as to who gets your stuff. And so, like I mentioned before, court is time and money, right? It's typically anywhere between 5 and 10% of your assets to go through probate. So let's say there's a house for $100,000. That house alone is going to have a probate fee of around $5,000 to $10,000. And it usually takes anywhere between 9 and 18 months before a judge releases the asset to be distributed. So that might be something like a house where the judge is saying it can't be sold. And now 9 to 18 months later, he's like, sure. He or she is like, sure, you can go ahead and sell it now. Well, all the while, someone's got to pay the taxes, mow the grass, do the upkeep, maintain the house until it's ready to be sold. With a trust, you don't have to do any of that. A trust completely avoids probate, and someone can immediately sell the home or distribute the assets pretty close in time to someone passing away. So I think that's probably the number one thing that people don't understand, the difference between will and trust. And a lot of families are looking to avoid that court process just because it's time consuming and expensive. The next big difference is a trust is a private matter, where a will is a public transaction. And what I mean by that is, this is why we see when celebrities do terrible estate planning, we get to see how much there was, who got what, and it's kind of an entertaining story, right, as to who gets all these millions of dollars. Well, for you and I mean, someone might not be looking at who's getting our millions, but what is more important is everyone gets to see how much there was and who got what. So now the kids might start fighting over why they think they deserve more. And I can't tell you how many families I've seen completely ripped apart because they're just fighting over assets. There was just a family actually that we were working with a year ago. The estate was worth $2 million. So I'm like, cool, great for them. But they decided very easily on all the financial assets, but they couldn't decide on mom's costume jewelry. And there was only about, $5,000 worth of costume jewelry, and they spent $165,000 to fight over who got some of the costume jewelry. I'm like, seems like a good use of resources, but whatever. I mean, that's just because what happens when something goes through probate is all the beneficiaries get notice and they get invited into court to say, why can I raise my hand and get more than maybe I was left in the will or the trust? So, or the will, because it's going through probate. So that's why it can be important to keep things private. The person just knows, yeah, you got a check for $20,000. Here's your inheritance, and now we're done. And that's all that they need to know about. The next main difference between a will and a trust is that a trust gives you so much more planning flexibility. And what I mean by that is, in a trust, let's say there's some minor grandkids that we want to leave money to. In a trust, you can say things like, well, it can be, until they turn age 25, the grandkids can use the money for education, medical bills, a down payment on a house. I mean, pretty much you can lay out whatever you want to for what they can use the money for, but it's held in trust for that benefit. They can't use it like an ATM machine until like you say so. So if you say, they get half at 25, half at 35. They only have access to half of the assets at 25 other than really important stuff. And you can do that stuff in a trust. You cannot do that in a will. In a will, it's just an outright distribution. So it doesn't matter really what's going on in the beneficiary's life. It's like, here you go, and best wishes to you. Which goes to my fourth and final thing, is that in a trust, we can protect assets for people, and in a will, you cannot. So right now on the screen, I have up there the differences of a revocable living trust. And we're going to talk about the differences between an asset protection trust and a revocable trust. But this revocable trust is probably what, if you go talk to your neighbors and they have trusts, they have one of these, is most likely. 99 out of 100 people have revocable living trusts. And in this type of trust, we can still protect assets for your beneficiaries. And what I mean by that is, let's say you have a son who's in the middle of a divorce when you pass away. Under a will, that son would get the distribution of assets and would have to split it with the soon-to-be ex. In a trust, there's built-in protections, at least the trust that we do, that could withhold that distribution if there's something bad going on in their life. Maybe they were in a car accident and they're being sued, which is probably going to happen now with all these changes in the auto insurance industry. We can protect that distribution, let the bad thing happen, and then give them the assets that you wanted to give them. Very, very similar to that, we can protect the assets from themselves. Let's say we don't have a crystal ball, so we have no idea what the future looks like. What if one of your beneficiaries has a drug or alcohol problem, and a distribution to them, they would not use it appropriately maybe. The trust can withhold that distribution until that individual, essentially got their act together, or whatever you want to call it, they're in a better place to receive an inheritance. So we can protect against those things. You can't do that in a will. In a will, it's just an outright gift distribution. It's going to happen regardless of what's going on in that person's life. And like I said, we don't have a crystal ball to know what the future looks like. So it's kind of a gamble there as to, if everything's going okay in that person's life. The big difference with, so that's the main differences between a will and a trust. Now, in looking at an asset protection trust, the big difference here between this and what most other people that you talk to about trusts have is that we can actually protect your assets for you while you're alive. We can protect your assets from things like long-term care costs, lawsuits, creditors, bankruptcy. Assets in one of these trusts are pretty much completely off the table if something bad were to ever happen in your life. And so you still have access to the assets. That's a question we get all the time. If I put assets in this trust, are they like not available to me anymore? I can't use them for anything. And no, that's not the case at all. There's a lot of information out there. If you just start Googling this stuff, there's a lot of information out there talking about old IRS tax trusts. And of course, as we all know, the IRS, their rules are very strict. And if you put assets to avoid paying taxes, then yes, you have lost access to those assets. Yes, will they transfer to your beneficiaries tax-free? Sure, but you don't have access to use them during your lifetime. We don't really do many of those trusts anymore, really at all, because right now, federal estate tax, the federal estate tax for an individual is 11 million, and for a joint couple, it's 22 million. So there's just not a lot of people out there that tax is even really a problem to. Now, if anyone on this call has 22 million, I would be happy to stay on afterwards. We can chat. It's just not a thing. It's not really a thing that we're dealing with anymore in our tax climate. So the short answer to that is you have complete access to the assets in an asset protection trust. So don't worry about that. So next, let's start talking about long-term care and what is long-term care where it relates to Medicaid, long-term care insurance, those kinds of things. And so when looking at long-term care, the standard for getting a long-term care insurance benefit, Medicaid benefits, VA benefits, it's a 3 activities of daily living standard. So if you have difficulty with any of those 3 on that list, you would qualify from a physical standpoint for any of those long-term care benefits, okay? If someone has some type of cognitive impairment, it would trump everything on this list. So you wouldn't need to have 3. You could just have that diagnosis of dementia, Alzheimer's, something like that. And although that individual would probably have some difficulty with these things, one of those diagnoses, and you qualify physically for one of those benefits. All those benefits have both a asset qualification and a physical limitations qualification. So you have to meet both prongs, and we'll talk about what that looks like here shortly. So the next question is how do we pay for long-term care? And so on the screen, you have your options. Private pay is just simply using the assets that you've saved up over your lifetime to pay for your long-term care. Long-term care currently in the state of Michigan, especially southeastern Michigan, ranges anywhere between $10,000 and $15,000 per month. We're talking about skilled nursing. This is nursing home care. When your needs rise to that level, it's anywhere between $10,000 and $15,000. Statewide, the average is $8,600, but there's also a lot of rural areas in Michigan that bring that average down. Southeastern Michigan is pretty expensive. So private paying is your first option. Just use the assets that you save to pay down, and that can happen pretty quickly. You can deplete assets very quickly when spending $10,000 to $15,000 per month. Friends or family, that can be just awkward, but if you run out of money, you can look to your kids to say, hey kids, how about we all just divide up mom or dad's $10,000 a month nursing home bill? It's an option. I've seen it done before. Long-term care insurance. So right now, currently, long-term care insurance is, if you have a long-term care insurance policy from the 90s, early 2000s, where you have a premium of, let's call it $300 to $400 a month, and it covers you fully for long-term care, those things are like gold. Back when those policies were being written, they didn't understand how expensive this was going to be and the resources needed for it. So the insurance agencies or insurance companies, they well underestimated what this was going to cost. Now, if you look into a long-term care insurance policy, I've seen them as much as a premium of $6,000 per 6 months. And the problem with this is you could be paying for insurance on something that you might not ever even need. And so I haven't seen any good solutions. I know I talk with financial advisors in this space all the time. They are coming out with some hybrid policies that are more like a life insurance rider, where you would be reimbursed for your long-term care expenses after you pass away. That's one of the ones I've seen. I know they're trying to get creative on it because it's a need. I mean, I think statistically, over 90% of us will spend at least 3 months in a nursing home. And so they're coming up with solutions, but I just haven't seen any yet that really make a ton of sense. And then finally, we're going to talk a little bit here shortly about Medicaid and VA benefits. If you qualify for either of them, they are an incredible federal and state funded program that can supplement or completely pay for your long-term care. And so we're going to talk about that here in a second. So let's first jump into Medicaid and talk about that. What is Medicaid and what does it cover? I already mentioned it's a federal and state funded program that covers long-term care. There is 2 Medicaid programs. People get these confused all the time. There's Medicaid, which is like health insurance for people who can't afford health insurance. Their assets are so low that they cannot afford health insurance, and that's not what this is. We're talking about the Medicaid long-term care program. And so what it covers is, most of the time it's covering in nursing home care. They do have an in-home care program, but typically in most areas there's a wait list for that. So we worked with plenty of families that have gotten it, but it's not something that we're really trying to get people on because it's pretty difficult to do. Nursing home care is much more readily available, and that's pretty much what we're talking about when someone needs skilled nursing care. We've already talked about the physical qualification of it, but there's an asset test that goes along with this. The basics of the asset test are for a married couple, you can have approximately $126,000 in assets, one house and one car. So that's what your asset picture needs to look like in order to qualify for this Medicaid program. So a lot of times what we're doing is in that trust we were just talking about, when you put assets in an asset protection trust, they're also non-countable assets for the Medicaid program. So when you put them in there, you can still have $126,000 as a married couple outside of the trust, and you reach that asset level that is required to get Medicaid to supplement your care. With a single individual, the assets are much less. You're allowed one house, one car, and $2,000 in assets. So we have to get that asset level even further down, but we can do that with the Asset Protection Trust. With Medicaid, there is something called a 5-year look back. Essentially what this is when you go to apply for Medicaid or we apply for you, they want your financial statements for the prior 5 years. And what they're looking for is they're looking for, did this person give away their stuff so that we, meaning Medicaid, have to pay for that person's care? And if they see something like that, maybe 2 years ago, you gave each of your kids $100,000 each, whatever. You were like, I'm not going to use this. Here you go. What they're going to do is if they see a transaction like that in your financials for the last 5 years, they're going to issue you a penalty period. And there's an equation that they use to calculate the penalty period. But what they say is, okay, you gave away $200,000 of your assets. So we're not going to pay for your care for, let's say, 6 months. So 6 months, you have to figure out a way to pay for your care, and then Medicaid will kick in and start paying for your care. So, we're always looking at doing planning as early as possible to get ahead of that 5-year look back. But with that said, it's never really too late. We do in our office something called crisis planning, where someone could be in a nursing home right now and they're spending $15,000 a month on their care, and we can shut that off. There would just be a penalty period that they would have to pay through. But typically when a call like that comes in our office, we can usually hold on to about 60% of someone's assets if they did absolutely nothing and they need care like right now. If we have 5 years to work with, we can protect 100% of someone's assets. And it's kind of like a sliding scale there in between. If we do and protect someone's assets and then they make it 2.5 years through that 5 years, you're usually somewhere about 80–85% protected. And that all has to do with what kind of penalty will Medicaid issue before they pick up the tab on it. And so we're always trying to plan as soon as possible so we can get that clock running. And then the last thing I want to talk about on that is estate recovery. So in 2007, Michigan implemented something called estate recovery. This is where essentially if any of your assets go through probate, Medicaid becomes a priority creditor and can be reimbursed for whatever that they had paid of your assets. So if your house goes through probate after you pass and they paid $200,000 of your care, they get the first $200,000 from the sale of that home. So when we're doing planning for any family, one of the big goals is we need to avoid probate because we want to make sure that they can't take any of your stuff. Which leads me to another thing that I always want to talk about because we hear it so often is everyone's always asking us, can the state or Medicaid take my home, take this, take that? Can they take any of your assets? And they can't really take any of your assets, but looking back to that example where I said that that family gave away $200,000. Well, if they only had $200,000, now they have nothing to pay for their care, right? They would otherwise qualify for Medicaid because their assets are so low, they qualify physically, but they already gave away everything they had. They gave away that $200,000. So now they might be in a position where the house would typically be protected, but now they have to sell it to pay for their care because they have nothing else to use to satisfy the amount that the care is going to cost. So the state, Medicaid, they can't actually take anything, but usually it's just the result of improper planning, or just, we see a lot of families will read stuff online and do things, and we have to fix a lot of things a lot of times because the Medicaid rules are incredibly complicated, and if you don't do it correctly, they can penalize you for quite a long period. So let's next transition to talk about VA aid and attendance and how does this differ from Medicaid. So Medicaid is a provider that pays for your benefits directly. What I mean by that is anything that they cover, your nursing home stay, they just write checks directly to the nursing home. You don't see a dollar of it, they just take care of your bills. With aid and attendance, they actually cut a check to you in your name like a pension, and you can use it for whatever you want to use it for. Now, typically, you know, there's the same requirements physically, so typically you need to use it for your care. But the nice thing about aid and attendance is you can use it to hire a caregiver to come into your house. You can use it for things that Medicaid doesn't really cover, because Medicaid doesn't really cover until you're a heightened level of care, skilled nursing, those kinds of things. But if you're just in assisted living and you need someone to come in once or twice a week and help out, you can use your aid and attendance check for those things. The asset test is very close. It's a net worth test of, you know, right there at 123.6. The nice thing is that 123.6 is the same for a married couple or an individual. So where Medicaid drops down to, if it's just an individual, you're allowed one house, one car, 2,000 in assets. With aid and attendance, you can actually get it one house, one car, and the 123,600 for a single individual. So that's great. Also with this, there's only a 3-year look back. So we were talking about the financial statement requirement for applying for Medicaid. You have to give 5 years. For VA aid and attendance, you only have to do 3 years. So we could have done planning 3 years and 1 day ago, put it all into an asset protection trust, and you were completely covered. Where Medicaid, it's 5 years to get 100% protected. You know, there's obviously a big requirement here that you had to serve in wartime. So online, there shows all the dates of service. You just need 1 day of service during those periods, during those windows, and you would qualify. You don't have to be, you know, hurt during service or anything like that. You just have to have served during those periods of time. I think we're getting there. We're there. What questions do we have about any of the material that I covered tonight?
Mike, I've got a question. Let's see.
Okay.
I'm going to start at the beginning here. Okay, shelter. I think you answered the question, but it says, can you shelter funds from Medicaid scrutiny? Rita, you asked that question. I think you answered it.
What was it? Can you shelter assets from Medicaid? What would you cut out there at the last part?
Medicaid scrutiny.
Yes. Well, but you need to do it, you know, in order to have 100% of your assets protected, you need to do it 5 years in advance of needing care. We have tons of strategies for if you need care tomorrow or you currently are paying for care and we need to shut it off through use of annuities. Because what's nice about the state of Michigan is the state of Michigan is an unlimited income state, but it's a asset, how do I say this? There's a required asset base that you're allowed to have. So what that means is sometimes we can use the strategy of taking an asset, maybe like a brokerage account that you have 300,000 in, turn it into an income stream for maybe the healthy spouse or even yourself, and those assets are protected. So if we turn it into an annuity that pays you $2,000 a month, it's now an income, not an asset. That's one strategy that we use. If we're inside the 5-year window and we're paying for care.
Okay. Another question is, what is the state tax liability? The same person said Fed, as you mentioned, is 11 mil per single recipient. So I think she wants to know.
I think there's currently no state inheritance tax.
Okay.
Really?
Okay. Another question is, how is an asset trust different than a regular trust?
Good question. So the asset protection trust is a style of irrevocable trust. It doesn't mean that you don't have access to the assets. It's just there's like one more step you have to go through when pulling out assets. So there's a couple ways to do it, and we can obviously go over that with whoever's interested in doing it. But it's as simple as, if you needed to pull out money from a 401k with a financial advisor, you're gonna have to fill out a withdrawal form to do so. It's kind of the same thing. There's just one administrative step in order to take assets out, but you're in complete control. You're not giving it away to someone else, to a third party to control the assets whatsoever. You maintain, you're the trustee of the trust. You have complete control of those assets. The only unique thing that I need to mention is if you have to be able to hold the asset in the trust. And so what I mean by that is a 401k, an IRA, qualified assets can't be held in a trust. So sometimes if it's a 401k or an IRA, we need to convert those into something that we can hold in trust. And whether that's a standard brokerage account or something else, and we don't do these things. We work with financial advisors to do it, or even you can do it on your own if you are kind of financially savvy. But we need them in a non-qualified account that can be held by a trust to protect it.
Okay. Another question was, years ago, there was something called the Lady Bird Clause, which protected the wife from possibly losing the house. Is that still in existence?
So actually, that's a good question. It's actually a relatively new thing in the last 10 years. And so what a ladybird deed is, it's essentially being able to put a beneficiary designation on your home so that when you pass away, it avoids probate and maybe goes to one of your kids. There's no real, there's no ties or protection there for a spouse. Typically you own your home joint with rights of survivorship to a spouse. This is more so a strategy to avoid probate in the event that the owners of the home pass away.
Okay. Can a promissory note from a business sale be put into an asset trust?
Absolutely.
Hear that, Bill?
Okay.
Promissory note can be turned into an asset and put in the trust.
Yes, essentially, I think the question is there. If there's income or something being given to you from the sale of a business, you can have that note paid directly to the asset protection trust. You sure could.
Waiting to collect them.
Okay.
And why you would want to do that, just to kind of take that one step further, is because if a promissory note is paying to you directly and you pass away, then that promissory note is going to have to be probated, and a judge is going to have to say, okay, now this promissory note is going to pay to your kids. Where if it's paying to a trust, the trust doesn't pass away, only you did. And so what that means is it would continue to pay to the trust, and then the trust is going to say, where do those assets go?
Okay. A gentleman is asking, I served in the Air Force during Vietnam, but did not serve in combat. Am I covered for long-term care by the VA?
Absolutely.
Okay.
Yep, you do not have to have, some people refer to it as boots on the ground. You do not have to have that. You just have to have served during the window. And it sounds like you're in the window.
Okay. Any other questions?
So they wouldn't have to be disabled at all, they just have to serve.
No, Lori, just because I kind of caught what you were saying there.
Okay,
So it's still, just like Medicaid, it's still a two-part test. There's the physical limitations, and then there's the asset side of it. So from the legal perspective, we can get you qualified from the asset side. But until you reach the threshold of disability for VA aid and attendance, you would not qualify. It's that 3 activities of daily living standard.
okay.
Great question. Well, I guess I appreciate everyone having me on and listening to me on a Tuesday night.
Thank you very much.
I was
Thank
just
you.
answering some questions there, Mike. Thanks so much. I just put in the chat information to everyone, how to contact Mike. It's through Kevin Bauer, and I've got his email and the phone number. Mike, thanks so much for taking time from your vacation to do this. We really appreciate it. I will send the slides out to everyone this evening, okay?
I appreciate that. Yeah, and so
Thank you.
we offer free consultations. So if you have, a question, maybe either you didn't feel comfortable asking it on the group, or also if you have a trust and you want us to look at it to see if it does some of the things that we were talking about tonight, we'd be happy to do that, or just kind of go over your unique situation. So, take advantage of free consultations that we offer to anyone who attends a presentation.
Okay.
All right.
All
Everyone
right.
have a great night. Thank
Good
you
night,
guys so
all.
much.
Good night.
My
Thank
pleasure.
you.
Take care.
We've got
Thank you.
exercise at 10 o'clock tomorrow morning. Tomorrow is yoga.
And is this on Zoom? Do we just
Yeah.
jump right back on the same
Zoom.
link?
Yep,
I get to learn something from you guys.
it's a different link. It's a different link, but I'll send you the link.
All right, sounds good.
All right.
Take
Good night,
care,
all.
everyone. Bye.
Thank you.
Thank you.